you, Madam Chair. Members of the board. I think you can hear that, you'll hear very shortly, and you can see in the papers we filed, we have a very, very different perspective on where we stand and what is needed to be done next. We're here because the board suspended the process properly. We conceded to that because there was a lack of a water supply plan. That was the element that was missing from the application. We supplied that plan. In fact, we went beyond just supplying an updated water supply plan. We provided 10 specific requested items that the town asked for, so that there would be even further detail, even further information in this water supply plan than what might normally be filed before the board. That happened, and that may explain why the water supply plan this time was a little bit longer than the water supply plan that was in the initial filing. And I also point out that in the initial filing there was a lot of other information in the attachments and the exhibits that went with that. So the water supply plan that was filed with you recently had more detail in it. It had answers and more details and data to the 10 requested items by the town. But that wasn't enough for the town. They then moved to dismiss again, and they then asked for a stay of the process because of potential for future legislation, which the board properly denied. And that was not enough to stop them on this quest either. They then, joining with CLF, have raised other arguments regarding the water supply plan and the agreement with the town of Johnston. We see this as just an effort to delay the board from moving this process forward. And as to the other legal issues that were raised recently in the Superior Court, we will be filing a motion to dismiss very soon, to dismiss that litigation and to bring that matter hopefully back where it belongs before this board. Again, we look at that as a delay tactic. If all an objector needed to do to stop an EFSB process was to go to court and file a declaratory judgment action, you'd probably never reach a decision on any administrative matter before you. So we have a very different view of where we are and where we need to go as far as going forward. The disconnect, I think, it breaks down to what is the purpose of getting advisory opinions from agencies? And I think it's important to emphasize that the purpose of getting input from agencies is not in the statute and it's not in the rules to answer every question and every concern that anybody might have who's objecting to an application. The statute and the rules are very clear on how you are supposed to use the agency process to help you. The statute and Rhode Island General Laws 4298(9) sub B is very specific. It says, quote, that the agency of state government or a political subdivision of the state, which absent the chapter would have statutory authority to grant or deny the permit, license, variance, or assent, shall function at the direction of the board for hearing the issue and rendering an advisory opinion thereon. So that's number one. The advisory opinion process is there because without an EFSB process, a project such as this or a developer would need to go before boards and agencies in the normal course to get licenses and permits. But as we know, this board acts as a statewide entity that has preemption over all of those other licenses and permits. But, that being said, it will help the board to get the opinions and advice from the agencies and the entities that would otherwise have the expertise to render a review and to issue a permitting decision, a licensing decision. That's the primary reason you refer to agencies for opinions. Rhode Island General Laws 4298-9 sub C also makes it clear that the board should limit the scope of the agency's opinion when it finds that more than one agency may arguably have some jurisdiction over a similar matter, or a matter that maybe could be shared by both. In other words, you're looking to get the information from the agencies that best are able to assist you, and typically those are the agencies that have a permitting or licensing function. That's not the end of the process, and that's not the only way that information can be presented to the board, and evidence can be presented to the board, and arguments can be presented to the board, opinions and expert advice. You have a full hearing process. You have an evidentiary hearing that we originally had scheduled for 15 days. Maybe there'll be more or less days. It's hard to know in advance, but the whole point is that that's an evidentiary process where all parties, all interested parties, can bring their thoughts, their advice, their concerns with regard to any of the issues raised by the board and issues that are identified and explained in advisory opinions. There's a full process that's available, and it's particularly relevant, we think, to the town of Burrillville and the CLF, because they are full participants in this proceeding. Not only are they full participants in this proceeding, they've issued numerous data requests with the help and assistance of expert consultants. The town has a full team of experts that they've retained to advise them. Hundreds and hundreds of data requests have been issued and responded to. They might not like every answer that they get back. It may not agree with their approach to this proceeding. That's not a reason to refer a matter to an agency for an advisory opinion process, I would suggest. But it is something that maybe they have a difference of opinion about that they would like to present to the board. And the important point that I'll emphasize is that the town, as a host community, as a full participant in this process, should be presenting its views to you, and they will as we move forward. They don't need to have an advisory opinion process to answer and to respond to every single question that's come up in this process. So that's number one for perspective. Number two for perspective, I think, in response to CLF's arguments, is that this is not a different power plant project that you're facing. What? This is the same power plant project that you were presented with essentially from the very beginning. Yes, there has been a change to the water supply component to the resource that will be provided to the project. The project otherwise is relatively conceptually the same. Yes, there are some adjustments that have been made to some of the components of the project as the process has moved forward, and certainly in response to concerns and questions that we've received back as the process is supposed to work, with comments, with responses, with input from the public, and adjustments to the project as best we can to adjust for the concerns that have been raised. So to suggest that this is now an entirely new application is just false. This is still an application that's calling for a nominal 1,000 megawatt project, even though the ISO New England has not yet awarded a capacity supply obligation for that second turbine. That's a yearly process that will happen every year, and circumstances change every single year, and that's why it's a competitive process. But the plan at this point is essentially the same. So we've heard some description about some of the agencies that we think that the CLF and the town thinks should be referred to for future advisories. We break these down into 3 components. There are agencies that we agree should take a look at the revised water supply plan. We have some agencies that we think we leave to the board's discretion on whether you should or whether you think that it would be of value to receive some opinions. And then there are others that we absolutely disagree with the town and CLF that are necessary or warranted at this time. So I will go through each one of those categories. So let's first look at the water supply plan. I take issue with the argument by CLF's attorney that this water supply plan has vastly overcomplicated or complicated this process as compared to the original water supply plan. I submit that the original water supply plan, which called for the removal of contaminants in a highly contaminated well, the Pasco Utility District's authority, and the treatment of that contamination and the piping of that to the project for purposes of providing processed water was a very complex engineering project, a proposal. The plan now, as it stands, based on a reevaluation, as the board can see from the water supply plan, has vastly simplified, has vastly reduced the amount of water that is necessary for the process means of the project. And this is deploying the most efficient technologies available for an already efficient air-cooled project, to the point where the water demands are projected to be vastly reduced and that can be supplied by a handful of trucks per day over state roads. So our view is that the plan has actually been quite simplified from what it originally was as presented to you with the use of the Pasco water.
And why is it even?
So, as to what opinions you should get now, certainly the town of Johnston, as the host community for the agreement, should be asked for their opinion on the wholesale. On the water supply plan and the impacts or any benefits that are associated with that as to the town of Johnston. What about the Providence Water Supply Board? Certainly, there's been a question about this. Is there enough supply in the reservoir, in the Situate Reservoir to supply the needs for the project? From the public information we've used in our water supply plan, we have no concerns about the impacts, given the small quantity that we're looking at, and the large surplus that's identified by the public documents for the Providence Water Supply Board. That said, we think it would be helpful for you to get their official opinion about that matter. And while you're at it, sure, the Providence Water Supply Board should also, if they feel the need or if you ask for it, give you an opinion on the wholesale arrangement with the town of Johnston. It's our understanding that legal counsels for Providence Water Supply Board have on several occasions already advised the Providence Water Supply Board that it's perfectly in conformance with the law and the legal authority of the Providence Water Supply Board. The Providence Water Supply Board is a regulated entity. They have tariffs that are approved by the Public Utilities Commission. There's a bulk wholesale supply tariff to municipalities. That is the means by which the water is being supplied to the town of Johnston. So if you want to obtain the opinion of the Providence Water Supply Board, we agree that that would be helpful. The Rhode Island Department of Transportation would be a good advisory opinion for you as well. There's a traffic study that's been filed. That traffic study was revised to account for the water trucks. State roads are being used to provide the access to the project from Johnston through 295, Route 44, State Road 100. These are all areas within the Rhode Island Department of Transportation's jurisdiction. So yes, an advisory opinion from them could be very helpful to you as well. They also have a permit on application for a curb cut permit at the site that they can advise as well. Statewide planning, yes, statewide planning should review the water supply plan in the context of the overall state guide plan elements. And we think that would be helpful. At the same time, as Mr. McElroy requested, we do not think that state planning needs to revisit their opinion with regard to all the other matters that the town of Burrillville has a particular concern about asking for a specific input on specific state guide plan elements. It's our review of that opinion that when taken in full, the statewide planning examined all the goals and objectives for policies of all the state guide plan elements and we take them at their word that they were looking at them in a comprehensive fashion, and that again, where some of the elements may intersect with, say, environmental issues at the Department of Environmental Agencies at RIDEM, that would be a matter to which the agency that deals with environmental issues would be responsible for reviewing and advising, whether in the context of a permit review or in an advisory opinion to the board. So we disagree that statewide planning needs to go back and redo all of the various state guide plan elements that they've already reviewed in their initial opinion. And with regard to the Department of Environmental Management, yes, the Department of Environmental Management specifically asked for an opportunity to review the water supply plan when it's filed to determine if there were any impacts on environmental issues. So that certainly should be a matter that should be referred to the Department of Environmental Management. As to all of many of the other items that were identified that we have placed on the record, I just wanted to point out that, again, as a reminder, that the DEM has independent jurisdiction and authority over a number of environmental permits, and that many of the details involved with, say, the stormwater design management, the specifics regarding that, and some of the soil erosion plan elements, and the wetlands elements are all going to be reviewed, we expect, in full detail as part of the permitting authority of that agency when they get a chance to do that. So we recognize that, yeah, that's a little bit of a different situation than some of the other agencies to which you have the primary jurisdiction. And that's it as far as the agencies that we think are absolutely important and necessary for you as far as reviewing the water supply plan elements. There's one other town entity that's the town building inspector. As we pointed out at the last hearing where we were here, or actually it was in regards to the motion to dismiss, the town building inspector is one of the few agencies and entities that has a special independent, not independent, but a separate role to review final plans that are submitted with all the conditions that are attached to it, as prepared by an engineering procurement contractor for a final building permit, which is after a licensing process. So we pointed that out, that's the typical review process for a building inspector. It would happen after a licenses process is completed with this board. That said, we have filed, as Mr. McElroy pointed out, we have filed conceptual plans, conceptual designs, and a preliminary soil and sediment control plan and drawings with the building inspector. So we don't have an issue with you receiving a supplemental review of that, of those elements of the information that is now sitting with the town's building inspector. Now that's as to the advisories that you should get, that we agree are necessary to you, and those that you should receive. Now let's turn to the ones that we do not agree on. The town planning and zoning boards. Again, as I pointed out at the beginning of my presentation, the town is a full party with experts, with opportunity to receive the input from data responses and to prepare testimony and provide its views to you as in their official capacity, both as a town and as a full participant. First. Second, with regard to the revised water supply plan, it involves trucking a small amount of water off-site for wastewater disposal, which involves trucking a few trucks of water coming in from outside Burrillville into the project, with no impact at all on the town's aquifer, its water systems within its town's jurisdiction, with no special use permit that is required, no variance from zoning that's required for a water truck to provide a delivery to a project or to a premise in the town. There's no reason to send this back to the town planning board or zoning board to have a complete review of their planning and zoning boards. Again, they will have the opportunity to present their views to you when we come to the hearings part of this process. And that's also true with regard to the tax assessor. And with regard to the other town entities that there were that I might have missed. Again, those views can be presented to the board, or if they have particular questions, they can ask us for more data, and they know how to do that, as we've seen from the hundreds of data requests that we've received. Now, what about the Public Utilities Commission? This was an area that both CLF and that the town of Bartlett requested. We disagree on that one as well, as you can see from our papers. The point that well, I should say this, that when I was reading the arguments made by the town and by CLF, and again, what I heard here today, briefly, was a repeat of the closing arguments that they made to the PUC last year during the advisory opinion process. But merely because they disagree with the conclusions that were reached by the commissioner last year is not a reason to have a do-over, essentially a do-over of that opinion process. They are asserting that this new evidence that's been developed that was not available at the time the commissioner rendered its opinion. Well, we disagree on that. The fact that Invenergy had a capacity supply obligation for one turbine, that fact was reviewed by the Public Utilities Commission. That remains the same today. No change. The fact that Invenergy did not have a capacity supply obligation for the second turbine was reviewed and considered by the Public Utilities Commission. And he determined that there was a need for this project even without that second capacity supply obligation. That fact remains the same today. The other points that were made in the papers by the town and by CLF with regard to how this latest the latest FCA 11 process produced a surplus of energy, and that even backing out the 485 megawatts of the first turbine, you would still be left with a surplus according to the ISO. That was the exact same set of facts that were presented to the Public Utilities Commission last year. So CLF is absolutely wrong when they say that the Public Utilities Commission did not consider those facts in rendering its opinion. I'm going to read one quote from the PUC's opinion that proves this. Quote, CLF has argued that Invenergy is not needed because there will still be an excess capacity if one were to take the auction results and simply back out the CREC Unit 1 portion. End quote. That's the same argument we just heard today. The Commissioner determined this, quote, this argument is not persuasive. There is no assurance that any of the new resources will be built. Nor, for that matter, is there any guarantee that all of the existing resources will deliver, end quote. He was referring to the other obligations, capacity supply obligations that were awarded. Those are still awarded, and the uncertainty regarding their delivery remains the same. So, in short, the reasons explained by the Public Utilities Commissions last year remain the same today. As regards to the ISO's statements that were relied upon by the Commissioner, number one, the ISO is estimating that 30% of the region's generating capacity could be gone in the next 10 years. That was the fact, state of the facts before the Public Utilities Commission, as represented by the ISO New England report. That report is exact, the latest report of January 2017, as I pointed out in our papers, says the exact same thing today. Similarly, the statement that 10,000 megawatts of retirement projects, or projects that are facing retirement, are at risk for closing. That statement that was presented to the Public Utilities Commission and formed the basis for his determination of need, that remains the same today. Again, in the 2017 ISO New England presentation. The statement that based on this is a quote from the Public Utilities Commission, based on the record, I am convinced that energy efficiency and renewable energy supply cannot at this time reliably meet the need for which the CREC project will be built. The record revealed that at least for the foreseeable future, generating units such as the proposed CREC facility are needed in order to meet Rhode Island's clean energy goals. End quote. That statement by the Public Utilities Commission, again, was just repeated in the 2017 ISO New England report by the CEO of the ISO. So these circumstances have not changed. So why would there be a need to go back and have that opinion redone? I suggest to you the reason they want to go back and do it is they did not like the conclusion that was reached in the advisory opinion process the first time, and they want to have a second crack at the apple. They want to have a redo of that. And I would suggest that's not the reason you should be sending matters back to the agencies. With regard to the costs, you heard some argument about how that the cost profile has gone up. What they don't tell you is that in the PUC's advisory opinion, the PUC had already explained that a detailed examination of costs that a private entity is going to undertake for a privately financed merchant project are not something that the Public Utilities Commission needs to delve into since the market was restructured in 1996. Again, there's a little bit of a disconnect in terms of the EFSB statute, which was enacted in the 1980s at a time when the Public Utilities Commission regulated as a monopoly service the generation of electricity. Narragansett Electric was a regulated electric generating utility. Its costs that it was financing for a project were picked up at that time and paid for by ratepayers. Because of that fact, it was very important that the Public Utilities Commission delve into the costs and the assumptions that were being made by a project. Because ratepayers were going to be asked to pick up that tab. That is no longer the case. And if you look at the PUC's opinion, it explains that in sufficient detail. They identify, quote, that the risk is on Invenergy, not the ratepayers, end quote. Again, quote, if there are any savings from the capacity markets, the energy markets, and with the risks of the project falling on the applicant, that's all that they were looking at. Again, the reminder by the Public Utilities Commission, this is not a ratepayer finance project. So it was no longer a subject of concern to go into a detailed review of the costs of a private finance project. The town or CLF, they might have other curiosity reasons why they want to go poke around and look at the cost profiles of a private company. But that's not a sufficient reason for you to send this to the Public Utilities Commission. Now, shortly, a quick discussion on timing. The argument made by CLF was that, well, the original water supply plan was 11 pages and you asked for 6 months. This water supply plan has 80 pages, so it doesn't make sense that you wouldn't ask for a complete 6 months. Again, I think that's a misleading argument. Of course, the first time you asked for advisory opinions, the agencies were reviewing, I forget how many pages in the original application, but it was over 500 pages, reviewing every issue that the board was concerned about. Of course, the agencies needed a lot of time to do that. And to come full circle, again, we're back down to a very narrow scope of review for a water supply plan that is limited in scope and is less complicated than we originally proposed. So therefore, I would suggest that a full 6 months for review would not typically be necessary for an opinion on a narrow, discrete set of issues related to the water supply plan. One suggestion I have, in fact, to help move the process along is that to consider a status review or a update from the agencies, say at a halfway point. It may be that the agencies are able to render their review in a very short period of time, depending on their review of the water supply plan. For example, it may be that after looking through the water supply plan, an agency may determine that, this doesn't really seem to impact a lot of the environmental issues on my plate, or traffic issues, or whatever. And they may, in fact, render a decision, or be in a position to render a decision sooner than of the time that you then allot them. So you can ask for that update, and if it turns out you received the opinions earlier, great. And then you can set the schedule accordingly. Finally, with regard to experts, there was some comment about expert opinions. Again, our view is that this is a matter for the board's discretion. You certainly have the authority to go hire an expert to help you, advise you on any of the aspects of an application. Actually, I think it's the board statute that we point to, Rhode Island General Laws 42-98-17, which is the specific statute that authorizes the board to employ on a contract basis experts. I think the rules that were cited by the Council for CLF and for the town actually talk more about the board's ability to ask witnesses to come forward and testify at the board hearing process, meaning that you don't need to get pre-filed written testimony from an individual that you would like to hear from at the point of an advisory opinion, at a final hearing process. So yes, you can hire an expert. The question for you is whether you should. We certainly do not think you need to hire experts for the lineup that the town suggested with regard to need and cost and environmental impacts, because you already have those experts available. The division has an expert, Mr. Parker, that was referred to earlier. He will be available for testimony. You have expert opinions from the planning department on jobs and economic impacts and the other areas that they are able to testify to. There'll be environmental issues. You're going to hear from experts, both from the town, from the state agencies, from our experts. So our point is that you have a sufficient supply of experts already at your disposal to assist you as you move forward to the evidentiary hearing process. If the board thinks it needs a particular expert, we're not going to stand in the way of that request. That's the board's call, and up to the board to decide. Thank you. Oh, may I just interrupt for 1 second? There was one area of opinions that I forgot to leave out, and that had to do with regard to the town, the other towns that were recommended. The town planning departments, the tax assessors, the town inputs through an advisory process from Gloucester, Smithfield, Johnston. Again, I think this wraps back to the point I was making earlier. Those towns will have no permitting overview of this project. Those towns do not provide permits and licenses to every truck that's bringing water through a state highway that just happens to go through their town. So I would suggest that it is not necessary to receive an advisory opinion process from each and every one of those towns, and that goes to the tax assessors as well. As the chair pointed out at the last meeting, there's plenty of opportunity for any town to provide its input or comments to the board with regard to any project that's before you. And that's different than saying, well, this is an advisory opinion process that we think you need to undertake. Again, state roads are being used to supply the water trucks. Now, last with regard to, there were some other state agencies with regard to Department of Health, OER, the Water Resources Board. Again, with regard to the Department of Health, the Department of Health expressed a concern about, an ability to comment on the water supply plan. Again, remember, at that time, the Pasco Utilities contaminated water supply that was in their aquifer there. That was what was being reviewed. So yes, we could see that there was an obvious health concern with regard to the water that was going to be pre-treated and then reutilized for purposes of processed water. But I just ask that now you've been provided with a water supply plan that's receiving potable water from the Providence Water Supply Board system, I just question whether there's a need for the Department of Health to actually go through and do a complete revised or supplemental advisory opinion. And again, if they have comments or concerns, they can certainly present them to you. They can certainly ask us a data request or an information request, and we can provide updated information. With regard to the Water Resources Board, again, it's the Providence Water Supply Board that really is the entity of interest for purposes of water supply. Again, the removal of a pipeline project, Pasco utility pipeline project or otherwise, we don't see how the State Water Resources Board would otherwise have an oversight of water trucks being used to supply water to a commercial project like this. So I question, again, the need for a water resources, state water resources board advisory opinion. And last, with regard to the energy resources, you've already received what we think is a complete opinion with regard to the compliance of the project with the Rhode Island Resilient Act and the goals that were set forth in the Act, and with regard to the air emissions reductions that are expected by this project, both regionally and in Rhode Island as consumed. So, yes, there has been an updated report. There's been a report that's been filed by the EC4, a report of recommendation, a high-quality report. We certainly value that input. That report, as we understand it, took into account this project in their base case analysis, and that report set forth, the start of a conversation, I think was the term that was used, to advise or at least to assist the other policymakers in the state and General Assembly and the state agencies with reaching and meeting the goals that were set forth in the Rhode Island Resilient Act. So, we don't have a real strong opinion one way or the other as far as whether you need to get a supplemental statement from Office of Energy Resources with regard to that report. We leave that to the board's discretion. If you think you need further input from them, again, this project will need to comply with whatever legal requirements are imposed by the legislature, by agencies, to implement any of the recommendations that are received to help the state meet the goals of the Rhode Island Resilient Act. And so that's our view about the Office of Energy Resources opinion. I think I've covered everything I wanted to cover.